federal society. FedSoc is a group of conservatives, libertarians, and even moderates interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. It is my pleasure today to introduce our distinguished guest of Berkeley Law, Professor Josh Blackman. Professor Blackman is a professor of law at the South Texas College of Law in Houston, specializing in con law, Supreme Court, and the intersection of law and technology, amongst pretty much everything else. He knows everything.
Too much. Too much.
He's the author of 3 books, Unprecedented, The Constitutional Challenge to Obamacare, Unraveled, Obamacare, Religious Liberty, and Executive Power, and most recently, An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. Professor Blackman was selected by, there it is.
Buy your copy. Bestseller. Bestseller.
For the 30 Under 30 in Law and Policy. Yes, twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He's an adjunct scholar at the Cato Institute, and he's the founder and president of the Harlem Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court Fantasy League, and he blogs now at Reason through the Ball Conspiracy.
Up to my bio, yeah.
Yeah, and he is the author of dozens and dozens of law review articles. He's written commentaries on a bunch of news sites. And today, Professor Blackman will be speaking to us about the future of the Roberts Court. And if any of you guys are active on Twitter or just if you guys regularly check Reason, you'll see that he writes a lot about these topics and is an expert on these topics. So,
sometimes too much.
Well, after the speech, Professor Oren Kerr will offer some brief remarks, and after that, we will reserve some time for the Q&A at the end. And you guys can all participate in that through the Q&A function at the bottom of the screen. And Professor Blackman, I wish we could give you a round of applause, but I'll just give you mine. And you know that everyone else is sending their welcome your way.
Thank you.
And we're really excited to have you here, and it's an honor to have you here.
Thank you.
Now the floor is all yours.
Thank you. And I know Min is coming to Texas after you graduate, so we will welcome you as a not a natural-born Texan, but as a transient Texan. I'm an interloper also. Thank you so much, Min. Also to Oren, my old dear friend. We've known each other for a very long time. And I think he might be the absolute perfect person to have discussing this topic with me today, because I think he and I represent different wings within FedSoc of how different things are approached. And we consistently disagree on a lot of issues, but we always do so in a good faith way. So I'm deeply grateful that Oren's here with me today. When Min invited me to talk about the future of the Roberts Court, I kind of assumed it would stay the same for at least a few more months, and go figure. I think Justice Ginsburg's passing, not even 3 days ago, has thrown a lot of what I thought would happen somewhat up in the air. But I want to start with more basic principles. During the introduction, Min said that Federal Society is a group for conservatives, libertarians, and moderates. And I think that historically that's been accurate. There are different wings, or different factions, there are different groups within FedSoc that disagree on a lot of things. And I think a lot of those fissures have become much more pronounced since President Trump's election. But at bottom, I think there are certain shared commitments among the conservative legal movement that sort of unify these disparate wings. Perhaps one is a fidelity to text. Perhaps another is the strong preference for federalism. Perhaps another is originalism, whatever you interpret that as, the divisive term. Maybe another is limited government, although we can disagree what that actually means. And historically, one of the uniting principles was opposing judicial activism, whatever that means. So there were certain threads that I think linked the various wings within the conservative legal movement. There was a synergy, or what might be called a fusionism, that was very prevalent during the Reagan administration, that kept things together. And I think that thread held pretty strong for a good 20, 25 years. But I think those threads started to come apart in the last decade or so. I can't really pinpoint exactly where this change occurred, but those threads start to come apart. And I think with the election of President Trump, the conservative movement, however you want to define it, pivoted and took a different direction. Limited government was no longer essential. Federalism wasn't really important. In some cases, you wanted a strong federal government to do stuff. And textualism and originalism just seemed to become less salient. When Justice Scalia died, I think President Trump was able to put his stamp on the legal movement by putting out his first list, right? And these were judges who were nominated, I think, almost exclusively by George W. Bush. Some state judges in there as well. But these were judges who I think were within the bounds of the traditional FedSoc movement. People like William Pryor, Judge Dan Sykes in Wisconsin, Tom Hardiman from Pennsylvania, and a handful of others. By the way, two names not on that list, Neil Gorsuch and Brett Kavanaugh, were not in the first list. Later, Trump had a second list. He added a name, Neil Gorsuch, who was the pick. Justice Kennedy retired, and we got another pick. We got Justice Brett Kavanaugh to replace Justice Kennedy. And as the court seemed to be becoming more conservative, I started noticing some dissent within the ranks. And I think a lot of this dissent focused on the more social issues, right? I think Justices Gorsuch and Kavanaugh were primarily picked for their views on things like administrative law, right? The separation of powers. If you were to poll the average Republican voter and he would ask you, which case would you rather overrule, Chevron or Roe v. Wade, right? Or which case is more important, our deference or, Obergefell, right? Pick your case. I think there is a schism forming that certain of the more libertarian parts of FedSoc were truly and honestly more concerned with things like Chevron and our deference. And there were other wings that were more concerned with things like, Roe and substantive due process and things that have a more social bend to it. And I think this sort of schism came to the forefront last term with a case called Bostock. Bostock was a case involving Title VII of the Civil Rights Act of 1964. The statute enacted half a century ago says that it's prohibited to discriminate against a person on the basis of sex because of their sex. And for the longest time, that was understood to mean biological sex. People said, of course it doesn't mean sexual orientation or gender identity. That's absurd. But over time, textualist arguments were developed that I think made it. I'm not persuaded by it, but I absolutely think it's plausible. I think the Gorsuch opinion is wrong, but I think it's plausible that you could use textualism to read Title VII to prohibit LGBT discrimination. Now, again, I can sit here as a law professor and say I think it's plausible. I think it's the best reading. But when we got to Bostock this past term, Justice Gorsuch's opinion was not popular. In fact, it created a backlash. How a Republican-appointed justice, a Republican by Trump no less, could reach a result that read a 50-year-old statute to prohibit LGBT discrimination. People blew up over it. Perhaps the most high-profile blow-up was by Senator Josh Hawley. You may know him as Senator Hawley, but Orrin and I knew him as Josh back in the day. He was a law professor at Missouri for not very long, maybe for a year or two. He shot to the top. We're still here wearing bow ties and sitting from Zoom screens. He's a senator, so what do we know? But Josh Hawley identified what he called the failure of the conservative legal movement. The failure of the conservative legal movement. And I want to just read you a passage from his speech. He gave it the day Bostock was decided. He said, "This bargain was never articulated explicitly, but religious conservatives knew there was a bargain. Here's a bargain. You go along with the party establishment, and you keep your mouth shut, and in return, you get some judges who will protect your right to freedom of worship and free exercise of religion. How does that work for us?" Hawley said, "If this is what textualism gives us as Bostock, what good is textualism, right? Why do we need it? Now, I think it's easy to just dismiss Hawley as an opportunist. He's running for president in a couple of years, didn't you know, right? I think you can just dismiss him. But I think Hawley is very good at targeting fractures within our polity. He knows how to tap that very effectively. This was a Trumpian vibe. He's very good at that. And I think he seized upon something that those of us in the legal conservative movement should be aware of. Now, if Hawley is the political force, I think the intellectual force of this movement is Adrian Vermeule at Harvard Law School. If you haven't read Professor Vermeule's article, Common Good Constitutionalism, go read it. It's a good read. I mean, I think it's easy to read. He makes his point very clear. There's no doubt about it. But he articulates what Hawley's getting at. Adrian says that there's no implicit reason why conservatives should favor originalism or textualism, right? We were sold a bill of goods by the libertarians, people like me and Randy Barnett. It's like these libertarians basically captured the conservative movement, and they were giving us things like Chevron deference and our deference. Who the hell cares about that stuff? We care about abortion. And he says we need to abandon originalism and favor what Adrian calls common good originalism. I'm sorry. Common good constitutionalism. It's a mouthful. Common good constitutionalism. And this is the notion that the judges should read the Constitution to promote the common good. Now, you can see both scare quotes on Zoom. Common good. Now, what does common good mean? Well, according to Adrian, it's what the Catholic Church says. I'm being always slightly facetious, right? Adrian is an integralist. He is very open about this. I'm not being pejorative in any way. He will look to Catholic teaching to define what is in the common good. Now, I don't agree with that. I'm assuming Oren probably doesn't agree with that common good, and my good friends at Berkeley sure as hell don't agree with that conception of the common good. But Adrian fervently believes this. And he would basically give judges a license to read provisions of the Constitution to promote the common good. So the Constitution says general welfare. Well, I don't know what that means. Maybe it means Catholic teaching. Who the hell knows, right? Adrian's trying to hoist living constitutionalists on their own petard, so to speak. He's trying to say, look, if the liberals can do evolving standards of decency and whatever morality in their law, why can't we do the same? But instead of evolving forward in progressive fashion, what's the opposite of evolving? Is it devolve? I don't know. We go backwards to Catholic teachings. Now, you may think that Adrian's a bit of a fringe. He's not. And I can tell you, his article was so well timed with the Bostock decision that a lot of people within FEDSOC and people that Warren and I know well are giving Adrian another look. They're saying, forget Randy Barnett. What good's originalism? Adrian can deliver the goods. And what would that mean? Instead of appointing judges who are originalists or textualists, you appoint a judge who has a moral philosophy. I'll get to Judge Barrett in a few minutes, I promise. But the litmus test is no longer what's your approach to interpreting the law. It's do you find abortion immoral? Pick whatever issue you want to have. That is present. And I think that social conservatism manifested even before Bostock. Professor Naomi Rao, who Oren and I have known for many years, she was my professor, is a federal judge in the D.C. Circuit. I think Oren will agree she's pretty damn conservative. I think her bona fides are strong. She's ruled in favor of President Trump in a number of executive power cases during a brief tenure in the D.C. Circuit. She's a Clarence Thomas clerk. Justice Thomas does not hire squishes. He's pretty good about that. Yet, Senator Hawley waged a public campaign against Naomi Rao because he wasn't sure if Naomi was pro-life. Apparently, there's some whispers, which I've never heard. I have no idea what her views are on abortion, but there's some whispers that Naomi was pro-choice. I'm sorry, Judge Rao. When our friends become judges, it's tricky, right? Senator Hawley, Judge Rao, right? When Judge Rao was being confirmed, Hawley gave her this really harsh treatment saying, how do we know you're solid on conservative issues? We don't care about separation of powers. We care about social issues. And I think Hawley was signaling quite directly that he did not want Naomi on the short list for the Supreme Court. And lo and behold, when Trump released his list, Judge Rao was not on the list. I think that was an unfortunate omission. But I think the omission of Judge Rao signals this schism that unless you have these sort of conservative social bona fides, you're non-starter, right? You're just not going to be there. Even though Judge Rao, I think, would be a stellar justice on the court. I think she's going to have a very successful career as an appellate judge. One of the few upshots is the fact that she's not on the list means she's sort of not tainted, so maybe she'll be in the future appointed by a different president, but we'll see. All right, so that was where I thought the conservative movement was until about Friday, about 6 p.m. or so. And then Justice Ruth Bader Ginsburg passed away. May her memory be a blessing. She was truly remarkable. I don't know if she can be ever replaced based on what she did, but it's a huge loss. I'm going to assume, for present purposes, that, at least for now, that Trump replaces her. I'll do the alternative where he doesn't in a minute. But let's just assume that Trump replaces her either before the election or after the election, before the inauguration or after the inauguration. There are all these permutations. But let's say Trump replaces her. And let's say that I don't know, Amy Coney Barrett's a nom. I don't know. It probably is, but we can reasonably assume that she'll be the nominee. At that point, the pole of the court moves. Chief Justice John Roberts would no longer become the swing vote. I think at that point, the swing vote becomes either Justice Kavanaugh or maybe Justice Gorsuch. I don't know. It could flip-flop. So all the Chief Justice's efforts to sort of mediate and moderate become irrelevant. In fact, I think it's more likely that Roberts will just join the majority assigned to himself to write a more narrow opinion. That's how he'll keep the court in check. So he won't be able to attract the liberals. He'll just keep the conservatives in line to make a more moderate opinion. That's going to be his new move. It's driving me nuts in a different way. But a lot of precedents that were sort of settled may look unsettled. I think Holman's Health was already on the rocks. I think it's gone. I don't think Roe gets overturned, but I think you get a chipping away of Casey. Affirmative action. I think the Harvard case is coming up. I think that case has a good chance of prevailing in favor of the plaintiffs. And I think colleges will have to revisit their affirmative action policies nationwide, public and private, because private colleges are bound by Title VI. Those are the huge issues I think can be changed in the short term. Now, let's say that President Trump goes ahead and nominates a candidate, and then he loses the election, right? Biden wins, but Trump gets his guy at the last minute. I think at that point, court packing is in the cards. It may take a year or two, but I think at some point we'll have 11 justices. And when that happens, I don't know how much good the conservative legal movement is, because it will become plain that the way to change legal doctrine is simply just to add more seats to the court. And I don't know how much usefulness there is for originalism when it's so painfully obvious that you're just adding bodies to vote in a certain way. I think it's the things that I care about doctrine, I think will just fade away. I don't know what my world looks like in that 11-member court. It's somewhat dispiriting to even think about just how the court will exist, because I think there'll be a sort of this race to the bottom where everyone's just adding more seats and adding more seats. Keep in mind also not only the packing of the Supreme Court, but I think we'll have expansion of the lower courts as well, right? Where you're adding more circuit judges to sort of dilute whatever gains President Trump made. All right, so what does all this mean for the future of the Roberts Court? What does all this mean for the future of the conservative legal movement? I think we're a bit of a precipice. I think this movement can go in one of two directions, right? If Trump wins and appoints a justice, then I think at that point that justice will stay on for decades, and at least for the remainder of Trump's term, we'll have somewhat of a normal semblance of the Supreme Court. And as long as Democrats don't control 3 branches, we'll keep at 9. And I think we'll have this sort of uneasy status quo where social conservatives in our movement start looking more askance at libertarians. I'm a libertarian. I get along pretty well, but I think my views might be marginalized. I think I might become an outsider. I'll be with a person with no party, so to speak. If libertarians sort of ostracized from FedSoc, it's not going to happen overnight, but I think it's sort of gradual. I think it will happen. I don't know quite when. The other option is if Trump loses and puts Amy on the another law professor, Judge Barrett in the Supreme Court, then we're looking at a very grim picture where doctrine just falls off, where all that matters is how many votes you have. I see someone saying in the chat, why am I so confident that court packing will work? It's never happened. The Senate favors Republicans. The Senate favors Republicans now until you add states, my friend. DC statehood and Puerto Rico statehood. That's 54 senators. At that point, whatever structural advantage you have is gone. Unless you make like a North Montana and a South Montana, I don't know, right? I'm sure you can get creative. That's why we have 2 Dakotas, by the way, to add more Republican seats. There's nothing new here. We can make a North Idaho, a South Idaho. There are different ways of resolving these issues, but I think okay, so let me just give you the chronology, and I'll turn over to Oren in a minute. I think there's there are 4 steps that would have to be done to do the court packing, right? You first have to eliminate the filibuster. I think that's done. I can't imagine the legislative filibuster stays if the Democrats have both houses of Congress and the presidency. At that point, I think you can add a justice to the court, or you can grant statehood to DC and DC and Puerto Rico, and then add votes to the court. You can flip-flop either one. I think you can go either way. But I think you add 2 more states, 1 or 2 more states, and then the Republicans' advantage goes away. But I'm not here for political prognostication. I think the more important point is, how will the schism between libertarians and conservatives form within our movement? And how will that leave different groups? One last thought. At Stanford Law School, they have a FedSoc chapter. I'm speaking there on Thursday. They have also formed a group called Stanford Law Conservatives, which is basically, libertarians not allowed. I mean, not explicitly, but saying we are not interested in libertarianism. We are social conservatives. And I think this schism is already becoming real. All right. I'll stop here. I'll be happy to answer your questions later. And I'll turn over now to my dear friend Oren to tell us why I'm 100% wrong.
Josh, thank you for that. And welcome to virtual Berkeley.
Yeah, right.
Zoom Berkeley, whatever we are right now. So there are 2 different parts of what you said, and I want to offer a couple thoughts on both of them. Part of what you were talking about was on the kind of the inside baseball of the conservative legal movement, Federal Society circles, legal academia, kind of that set of developments. And I think to some extent what we're talking about is the difficulty of having theory when you're in the majority. So let me give a little bit of context. The Federal Society was formed in the 1980s at a time when the conservative views were in the minority on the courts. And it was designed to be kind of a debating society about ideas that were not getting full attention in academia because of the general ideological slant of those that were in academia and professors, students, and all the above. And so the thought was, let's develop a set of ideas that are not political ideas. In fact, that are very much moving away from the courts as political actors, and developing legal theories that would be apolitical, that would typically lead to a narrower role of the courts, not try to put the Supreme Court in the center of American life, and have more predictable, more grounded judicial decisions. That was, and if you look at the Federal Society statement, it's about like separation of powers and rule of law, not of people, and so there's a set of principles there that reflects that birth. And you fast forward to today, I think what Professor Blackman, sorry, I'll give you your title too. I'll do the first name stuff. What I think Professor Blackman is talking about is, to some extent, all of that is well and good for politicians when you're in the minority. But once you have a majority, you start saying, well, why do I care about theory? Give me results. And so what Senator Hawley is talking about is, I don't care, or I think what Adrian Vermeule is ultimately talking about, I don't care about theory. I don't care about, this is the political view of the law. It is give me results. I want certain outcomes. That was the mindset that the Federal Society was originally founded to reject. And yet, it's becoming an increasingly significant force within the Federal Society, whether you sort of label it common good constitutionalism, which I don't think it makes any difference what you label it. Ultimately, it's like, give me a certain set of results. And so, I see this as a challenge to the fundamental principles on which the Federal Society as a group were founded, which was rejecting all of that. And maybe the answer is, when you're facing having a majority, theory is just like, put that aside, let's talk about what outcomes you can get, and then let the law professors figure out later what the theory was. And that was largely what had happened in the 1960s with the Warren Court. The Warren Court was about there are a set of results that the justices wanted, and then the law professor came in afterwards and said, looking back on the last 10 years of cases, here is the theory that the Warren Court was adopting. And it's sort of like an ex post, here's my effort to kind of explain what just happened, rather than a forward-thinking, here's a theory and where the law should go. So I see a lot of the political developments of the law as really a direct challenge to what the Federal Society has traditionally been about. And that's not to say that theories like textualism and originalism don't have a political angle to them. In fact, these are theories of interpretation which can be applied in a neutral way, but can also have a lot of flexibility and can be thrown up as sort of terms that are used to justify a decision which may ultimately reflect an ideological assumption. But the driving force behind textualism and originalism in terms of its academic development and its endorsement on the conservative side of things, the conservative legal movement, has been that they are not tools of politics. They are against that. They are neutral principles. And to the extent that maybe the answer is no one wants to talk about neutral principles when there are votes on the line, I think it's just a direct challenge to what the Federal Society should ultimately and historically was about. And now, granted, Professor Black was talking about maybe he won't have a party someday. I have no party now. As a never Trump Republican, I don't know what I count as anymore. Who's liberal? You have to say whatever you want.
Yeah.
I'm never happy. So I guess I'm independent now. I don't know what I am. But I think a lot of what we're seeing is the shift when there are votes on the line. And an interesting example of this is, think of the politics of how this is playing out right now. We have senators effectively saying we should confirm whoever President Trump nominates in the short window of time before the next election. Sort of the vote. We're going to get to the point where the senators should just vote before the president even names someone, because we all know how it's going to play out. It's going to reflect the politics primarily of the senators, and the party, realistically, of the senators is not going to be a great question of theory and textualism and originalism. There are other things that are operating here. In terms of court packing and all those sorts of things, I don't think they're wise. I think once you destabilize that, everything just continues to get destabilized. At the same time, I think trying to push through a nominee in an incredibly short window of time after having promised that the last year of a presidential term was one where you don't confirm nominees, and then sort of coming up with this new explanation for why it was that this is all principled, that I don't think they're going to actually. This is my 2 beers test. It's there's what people say, and then there's what people say when the cameras are not running and they've had a couple beers. And I think the couple beers test is everyone realizes, yes, this is just, they have the votes. This is not about some grand principle. And so it seems to me that, it's not like we can say, oh, the other side is not being principled and one side is. This is a ever moving forward in the direction of just greater and greater pure partisan warfare, and I find that incredibly unfortunate. And what could possibly fix that? One answer is just you have enough of a presidential balance over time that the Supreme Court roughly reflects the politics of the rest of the country. So no side feels like it's being completely cheated by this process. The other thing that I really think should happen is there should be the Supreme Court justice should be term limited. So every president gets 2 picks, 18-year terms, and therefore there's a predictable sort of ideological where the Supreme Court goes where roughly the presidents go, and it's not a matter of whether a particular justice lives a few months longer than they might have otherwise lived or does not. I mean, like, it's an incredibly weird system when the direction of the Supreme Court, with all of the power that the Supreme Court has, is dependent on whether 1 or 2 octogenarians live a little bit longer or not. I mean, it's an extraordinary system. So I think I hope for stability. I hope for going back to the principles here, but until there are term limits in the Supreme Court, which would require a constitutional amendment, I'm not optimistic. Okay, those are my thoughts. Have a good.
Thanks so much, Oren. Yeah, I think we.
You're muted.
Oh, I feel my lifetime is telling students you're muted. You're on mute. I think that I think we largely agree, and so maybe we could discuss for a bit. What does FedSoc look like in 10 years? In other words, if we'll do it both ways, Trump gets a pick or he doesn't. Let's just say Trump wins and Judge Barrett's there. Does FedSoc start hosting symposiums on common good constitutionalism? Do they start to have fewer seminars on originalism and more seminars on moral teaching? In other words, does FedSoc fill that void, or does FedSoc stick to its guns of not taking those positions? And does some other group fill that void? As students rise up in this sort of Vermeulean catechism, what's the next step? And I don't have the answer. Maybe you don't have a party. I don't have a party. I don't know what's next. Maybe has FedSoc reached its peak? Did it reach its apogee in 2018 with the Kavanaugh nomination? What lies ahead? I don't know. You tell me what you think. You've been in this game longer than I have.
So I do think of Adrian Vermeule's common good constitutionalism as just a fringe idea. I can't find anybody outside of Adrian Vermeule and like 1 or 2 people on Twitter that are actually fans of this idea. And it seems to me that even if you are, let's say you are someone who looks at the results Adrian Vermeule wants and likes them to some extent, you would use the same language and the same frame as everybody else in order to do it. I mean, there's sort of there's what ideas theory can produce, and then there's often, if not inevitably, going to be discretion as to result. And so, I'm not expecting there's going to be a significant break. I'm not worried. I'm not terribly concerned generally. What's the future of the federal side? It'll be whatever it is. There are bigger, more important issues in the world, obviously. But I think the bigger thing I'm worried about are the commitments that led to the creation of this group really ones that are going to continue to animate it, or is it more going to be, you could end up with a Supreme Court that has 6 conservative votes, 5 of which are very reliable conservative votes, and in which all the theoretical commitments sort of drop out. I'm worried about that, where you could, once you get a group that is not just doing theory, but is like, oh, cool, there are these votes. I'm concerned about what direction that takes, because then it suggests, how much of this was really about theory and how much of it was just let's get enough votes on the Supreme Court.
All right, that's good. All right, let's take maybe some questions from some of the students, please.
Sure. So it looks like we have a couple questions in Q&A here. The first one is from an anonymous attendee.
Anonymous attendee. Is this deep state? All right, go ahead.
I joined a few minutes late, so apologies if this was addressed. But will you be talking about the idea you presented about Kavanaugh/Gorsuch potentially being swing votes? So maybe you touch on that. Maybe you want to elaborate on kind of what the court would look like.
I think that's a fair point. If Trump gets replaced Ginsburg, and we'll assume we don't have court packing for at least a couple of years, we have a new court, right? Each new member of the court forms a new court. The Roberts Court has many iterations. We get a new court altogether, I think. At that point, either Kavanaugh or Gorsuch might be the median voter in any given case. And I think the dynamics change. As it stands now, or as it stood before Friday, the court's 4 progressives were willing to join anything John Roberts said, to join no matter what he said, to get to 5 votes to reach a result. And sometimes Roberts would sort of extract concessions to make an opinion a little bit more conservative and maybe set some doctrine for the future. Justice Kennedy sort of had this luxury for years, and that became Justice Roberts' a luxury. But now Roberts plus Breyer, Sotomayor, and Kagan can't do anything by themselves. They just don't have the votes to do it. So I think you would need to attract in either Kavanaugh or Gorsuch. We've seen that Gorsuch has sort of a libertarian streak in criminal law cases. Maybe Orrin can speak to that. That's his area of expertise. I don't know if Kavanaugh shares those inklings on crim pro cases. Maybe he does. So I think Gorsuch is the more likely gain. He voted with the liberal wing in the Bostock case and the case involving Indian Territory in Indiana, which was a really significant case that went under the radar. But I think you just see more different 5-member coalitions, but that's going to swing less often. I think that's just not going to happen as often. What may just happen is if there's 5 votes and Roberts isn't there, you get a 5-4 split. And I'm talking about the Second Amendment. If you read Joan Biskupic's reports and you credit them, the chief signaled that he didn't want any Second Amendment cases. He did not want a gun case. He's ruled against it. Well, guess what, John? You're not in charge anymore, right? You can have a 5-4 ruling to rule in favor of the Second Amendment, and the chief can just write a dissent, right? So you may actually get a cert grant after Judge Barrett or whomever joins the court on the Second Amendment. I think that's one area you'll see almost immediate granting because the votes were there except for Roberts. As for Kavanaugh, I'm still figuring him out. I know I'm very critical of him, but I do think the things he does I like. I'm still figuring him out. I don't know quite where he is. I think he's still burned by his confirmation hearing. I think he's still sort of walking on eggshells to avoid whatever he's avoiding. I don't really know what it is, but I don't think he's reached his full potential. I think he has greater potential, and I just think he's to spread his wings for a little bit. I'm eager to see what he does. Warren, what do you think about this new swing vote potential?
I mean, assuming it's Judge Barrett from the Seventh Circuit, and assuming she's confirmed, I think it's right that the swing votes. I mean, and when we talk about swing votes, we don't mean necessarily a centrist vote. We just mean the person who's the 5th vote to win. So, from a standpoint of a Supreme Court litigator, 4 means you lose, and 5 means you win. So the whole enterprise is, can you get 5 votes? And so the 5th vote, I agree, is likely to be, I think, a rotating cast, really between Kavanaugh and Gorsuch, depending on the case. In a criminal procedure case, it might be Gorsuch. But not Kavanaugh. I think he's pretty government-oriented in criminal procedure cases. But a different case, and it's a different swing vote. But one of the two of them, sort of like with Kennedy and O'Connor used to be, 10 or 15 years ago, it maybe alternate between the two of them as to who was the key vote in a particular case. So I agree that that's likely. And I wanted to say one more thing about court packing. I think a lot of the commentary about court packing is a rhetorical move, and it goes along these lines. Don't go where you want to go, because if you break this norm, we will break the next norm. And so we are going to try to ex ante deter you from violating this norm, or at least from not going as far as you want to go. And so I think a lot of these proposals, court packing is one of them. I'm sure there's some interest in it from some people, but there's a certain amount of don't do what you want to do now, or else we will maybe do something. And I think that's very different from whether they actually would do that going forward. So I think a lot of this on both sides, the nature of this process is there's so much political positioning that you kind of have to discount.
Yeah, one other dynamic is cert grants. As you all know, to grant certiorari, you need 4 votes. I think there are some cases where the liberals granted cert to force Roberts in a position. They wanted him to take a case, right? So the conservative lower court ruling, there are now 4 votes liberals granted, hoping that Roberts can reverse. I think that goes away. I think it becomes harder for the liberals to force a cert grant, and Roberts may just not grant as many cases. So one way we can measure this is if the number of grants it just drops. This term is such a bizarre term, but if we see grants are dropping or different kinds of grants are being made, that could be an indication. The long conference is next week, right, Oren? I think it's next week. Yeah. We may get 1 or 2 grants. I think they're not taking anything. It's like, what the hell is going on? Let's not flood this docket. We have Obamacare. We have Fulton, which is a free exercise case. We had enough. We're good. Just take a couple of RISA cases and we'll call it a day. Thank you. All right. Next question, please.
Can I add one?
Yeah, of course.
So I think not only, if Barrett is nominated and confirmed, not only would we have fewer grants from among the liberal justices, and you don't know, I should add, it's not public who's voting, so you never know. I think we're talking about a dramatic shift in a lot of areas of federal law driven by the conservative side. Effectively, we could be seeing sort of a conservative mirror image of the Warren court for some window of time. If you have that many strong conservative votes, just in terms of the amount of things that will change. I'm not saying jurisprudentially the same or anything like that, or the priorities would be, of course, quite different. But I think we could be seeing a period of substantial change in major areas of federal law that we haven't had in many years.
Okay. Looks like we have another question about Justice Gorsuch, actually. This one is from Jonathan Chacon. How should we understand Justice Gorsuch's future role on the court, especially with respect to Roe? On the one hand, he seems willing to ignore the preferences of social conservatives on some cases, e.g. Bostock. That's so strange. The question just disappeared.
Oh.
Sorry, it's because I clicked it as answered. I'm sorry, I didn't mean to stop that.
We can imagine it.
It's on there. It's on the second tab. On the other hand,
it's under the answer tab.
He finds to be flimsy on textualist or originalist grounds.
Okay, I see it there. I'm sorry. Okay, Jonathan, I'm sorry your question magically vanished. So here's my take on Gorsuch. I don't think he's very much of a social conservative. And I don't say this pejorative because I don't consider one either. I think one of the tells is in his opinion in Bostock. He referred to a person's gender identity. He referred to a person presenting as a man and presenting as a woman. He used the pronouns of no, it wasn't Bostock. It was one in Michigan. I forgot the one in Michigan's name. He used the person's preferred pronouns. Justice Alito did not do that. He did not use pronouns. He just used the person's last name. Justice Kavanaugh was very careful not to do either. He just did nothing. Right? He sort of danced around it. I think Gorsuch, agrees with Bostock. I don't know where he is in abortion. He joined the opinion this past term in June Medical suggesting that whole women's health is wrong. I don't know how far he's going to go. In my mind, the reason why Neil Gorsuch was picked by Don McGahn, the White House counsel, is for admin law, things administrative law. It wasn't for social conservatism. If you wanted a social conservative, you would have picked someone else. Gorsuch would not come to the top of the list. He just did not have that sort of, doctrine in his cases. So I don't know where Gorsuch goes, and I don't know where the court goes in abortion. I don't even know what this looks like. I think what you may see is that conservative states start to get more aggressive, enacting more rigorous trap laws, these restrictive laws on abortion, and they'll see what the court upholds. I think you're going to see a lot more bold moves from the states. Oren, where do you think Gorsuch is?
I think the key dynamic with Gorsuch is he's perhaps the least, he and Thomas share a trait where they're sort of the least institutionalists of the justices. That is, they are the most willing to rock the boat and most willing to say, well, the law has been one way, but let's change it and go in another way. And some justices, like Chief Justice Roberts, will say, are much more institutionalist, don't rock the boat, don't make major changes in the law. And I think Gorsuch is one who sort of likes making major changes in the law, like sort of gets, I think he has a sense that that's what you do because it is in his view following the law, and that when a court follows the law, even if it upsets a lot of expectations and dramatically shifts things, sorry, that's the power of the law, and so I suspect that he's a vote to cut back substantially, if not entirely overturn Roe. And so if I had to guess, I would guess he would be a vote to overturn or come close to it. There's a lot of exactly what does overturning count as setting matter, but or it matters, but exactly what does it mean is somewhat open to interpretation. But I suspect he would be a vote to change that.
Okay, our next question is from Kevin Chen. Do you have any thoughts on how the court would decide a contested election?
Oh, God.
The media constantly reports on issues with mail-in ballots.
Oh, God. You had to ask that, Kevin, didn't you? All right. Well, look, let me approach this in a couple different ways. I am going to assume on election day we have an 8-member court. And the reason why I'm going to assume that is even if Trump pushes through Judge Barrett, I think she's going to have to recuse. I don't know if Orrin agrees with me on this, but I think one of the first questions she's going to get from the committee is, you're being nominated by President Trump, right? Your nomination depends on him being elected president, right? Can you claim to be objective in a case involving the person who appoints you? Because let's think of the chronology, right? Let's say that election day happens and Barrett gets confirmed after the election. During that period, at any point in theory, Trump could withdraw her nomination. I mean, he won't do it. But is there a conflict of interest? I'm having a tough time seeing Judge Barrett or anyone else decide when the election case is. I mean, maybe she could say, I've thought about this. The Supreme Court is not subject to the normal ethics rules. It's really important to have a 9-member bench. We don't want ties, so I'm going to sit through it. And I think in the past, we've had justices who made decisions on recusal that were motivated by the need to have 9. Right? You can't have it. You know, that's how she wants to start her career. I guess she can do that. But I'm skeptical. So I'm going to assume we have 8. Right? I'm going to assume we have 8. I don't know if that's a good assumption, but maybe it's my assumption for now. We have 8 for any case. As you all know, when a court splits 4-4, it simply affirms a lower court judgment. There's no precedent that's set. There's no there's no rule. There's no opinion. It's like a 1-sentence order, right? The court's affirmed by an equally divided margin. It happens. It happens every year when there's a recusal. What does that mean? The lower courts get to decide whatever issue there is. That could be a federal court, or it can be a state Supreme Court. And I guess this cuts depending which side you sit on. You know, the Florida Supreme Court's pretty conservative. The Wisconsin Supreme Court's pretty conservative. The Pennsylvania Supreme Court's pretty liberal. I haven't looked at all the state court compositions, but depending which state an appeal comes from, a court of last resort may have the final say. The federal courts, it's a little bit better for Trump. Most of the swing states, by my math, are in states that have been flipped, if you want to use that pejorative. Ohio and Michigan are in the 6th Circuit, which has a pretty strong majority of conservative judges. Florida and Georgia are in the 11th Circuit, which again is majority Republican appointed judges. Pennsylvania is in the 3rd Circuit, which Trump has narrowly flipped. I suppose you have Nevada, which is the 9th Circuit, which is not flipped, but is not the same 9th Circuit it was when it was a couple years ago. It's a very different 9th Circuit. There are many more judges there that were appointed by President Trump. So if these cases are in federal court, there's a good chance the 6th Circuit may decide the presidential election. Right? That's just an insane thing to think about, but it's very possible that might happen. Or the 11th Circuit may decide the presidential election. Right? I can see the Chief Justice saying, no more Bush v. Gore. We write 4-4 tie and let everyone deal with it. Right? We just say firm but equally divided court and be done with it. Talk about a ticket good for one ride, right? It's literally a ticket just for that one decision. It's a 4-4 affirm. So I can see the most classic Roberts opinion ever simply being we affirm 4-4 and we don't say anything. I mean, you can call that maybe cowardice or restraint or whatever pejorative you want to use, but I think that's a distinct possibility. Now, the scary part is, what happens if Trump or Biden says, screw this, I'm not accepting a 4-4, right? I'm not letting the Pennsylvania Supreme Court resolve the election. I'm not letting the Supreme Court of Wisconsin, partisan court, decide this election, Biden. Look, Al Gore, for whatever his warts, in 2000 said, I'll abide by the court, whatever happens. He did. He didn't march in the streets. I don't know what happens if there's a 4-4 tie and the Supreme Court sort of says, we're not going to decide this. Or they can't decide it because they're evenly divided. They can't. Right? John Roberts can't extort Clarence Thomas a vote in favor of Joe Biden. It's just not going to happen. There's a vote, it has to happen. At that point, things get very dicey. There's no commission, right? There's no appointed commission. And at that point, it's up to the House and the Senate to count the votes. And if the Senate, which is presided by Mike Pence, decides to count the votes from Wisconsin for Trump, then that's the electoral vote. And then John Roberts swears him in. It's going to be ugly. The next, 44 days, I've lost count, are going to be not pretty. Oren, do you have any optimism here? I sure don't.
No optimism. I would just add that it's implicit, it's interesting in everything you just said, Josh, that you were like, whether it's a conservative court or a liberal court, Republican appointees, Democratic appointees, there was no, in your description of it, you didn't stop and say, well, here's the legal issue and here's the correct legal result. It's just sort of assumed that there will be partisan judges playing for their party side, which is what we saw in Bush versus Gore, to the extraordinary embarrassment of the Supreme Court. I mean, that was, I think, the Supreme Court. In particular, this was, if there's, there are different arguments about whether different sides of the political, of the Supreme Court are really true to their principles. I think Bush versus Gore was the worst moment for the conservatives, where they sort of just dropped all of it and were not following the rules that they would say that they should be following. So I think these are the courts at their worst, and I would just hope the courts try to stay out of this. And it's one thing to have, for it to get thrown into the House, and that's what the Constitution talks about, and let that be a mess there. But for the courts to do it, I think is to take this on. The lesson of Bush versus Gore, to my mind, is that the court should not try to get involved in this, and it's going to be a mess if they do.
Yeah, I appreciate that, Oren. Maybe I was being a little glib, but I think in this case, the ideology lines up with the politics, where generally conservatives tend to favor more stringent ballot access, and they don't want to extend deadlines. They don't want to, count more absentee ballots, and that I think is a more conservative position for however it shakes out. But yeah, I should have caveated that, assuming that the judges vote in line with the politics, and I friendly amendment taken. So I amend my statement. Okay, do we have time for another question, please?
Yes, we do. Next question is from Allison Talker. How would a potential conservative court limit the policies of a Biden administration? For example, would there be limits to universal health care or how the ACA, the Affordable Care Act, survives?
Obamacare. Oren, do you think about Obamacare? I've not been up to speed on that. Is there anything? No, I'm kidding.
Your corner of the world, I'm fine.
Yeah, no, I know. I mean, how could a conservative court? I mean, easily. The same way the conservative court has stymied President Trump, they can stymie President Biden. In fact, some people speculate that the reason why Roberts is being such a stickler for the Administrative Procedure Act is to set a precedent that can stymie future administrations of both parties. And maybe that's right, maybe it's wrong. But if you look at the DACA decision this past term, which I filed a brief in favor of the administration, what Roberts basically said is that whenever any policy is being changed, right, whenever you're changing a policy, you have to consider other options. You have to give them what's called a hard look under the State Farm Doctrine. And that's a very nebulous standard. And depending how hard that look is, the courts can invalidate almost any reversal. So if Biden tries to reverse some Trump policy 3 years down the road, Roberts will say, well, you didn't consider X, Y, and Z. And you didn't think about this little thing. And why didn't you do this? Remand back the agency, start over again. And presidency's over, right? President Trump spent 4 years trying to rescind DACA. And at the end, the president said, the court said, go back to the beginning, start over. Right? We don't live in a world of 4-year remands, right? We have a 4-year term limit, and you have to get stuff done. So I can absolutely see the Roberts court using these picayune admin rules to basically stop Biden from doing anything. And these are sorts of rulings I think would glide the skids, or to grease the skids, whatever it is, grease the skids for court packing. It's like, screw this, right? We're not going to spend 4 years trying to issue a regulation that's get killed at the last minute by the Roberts court.
All right, our next question is another from Anonymous FND. Do any of your observations or predictions change if Barbara Lagoa or someone else is the nominee? She seems like a better choice than Barrett from the perspective of Trump's re-election chances.
Okay, thank you for the question. Judge Lagoa, if you don't know, is a federal appellate judge in Florida, the 11th Circuit. She was on the federal bench for like 8 or 9 months, and before that, she was a Florida Supreme Court justice for about the same period. She was an intermediate court judge for about a decade. I don't know much about Judge Lagoa. I've never met her. I've only read a handful of her opinions. So I don't have much of a basis to say what I think about her jurisprudence. I'm being perfectly candid. I've read a lot of Judge Barrett's work. I knew her as a scholar for a decade, so I know her. I don't know Judge Lagoa. Now, the question was premised, would Judge Lagoa help Trump's electoral prospects? Do people really think about the justice when they're voting at the ballot? I mean, it's such a weird thing. I mean, does Mike Pence help Trump get more votes in Indiana? Right? Would picking a Cuban refugee's child help votes in South Florida? I have no idea. I mean, that's a question above my pay grade. From my perspective, I think it would be a mistake to put someone on the bench for 40 years because they might generate a few thousand votes in Hialeah, right? That just seems like a very bizarre thing. But again, I'm not a president, thank God, right? I'm a law professor. I care about doctrine. I don't, so I don't know. Oren, do you have any sense of whether that stuff matters?
I suspect that Lagoa is being put forward as a key person in part just to try to help with the Florida vote, as in, Trump can say he looked really carefully at her, and people in Florida can feel good about our person who was in the running and wasn't that great. I suspect that it's all really about Barrett, because Barrett is going to satisfy the social conservative wing that is upset after Bostock, and is ready, is really going to go to bat for Trump if he's seen as delivering. And Lagoa is just an unknown, so people don't. And after this sort of the No More Suitors call, which for years was the driving force in a lot of the Republican side politics about the Supreme Court. And I think Lagoa is just so much of an unknown, former state Supreme Court justice, just on the Federal Court of Appeals for a year or so, just like David Souter had been. So I strongly suspect that they wouldn't, that Trump would not nominate her. The politics are that people would be upset by that, and would be, in the circles that Trump is looking to really motivate, would be thrilled by a Barrett nomination.
By the way, did you see that apparently Judge Larson volunteered for the Biden campaign in 1988 when she was like a teenager? This is ridiculous. Judge Larson's a federal judge in Michigan, the Sixth Circuit. When she was she a teenager? She volunteered for the Biden campaign in Iowa in 1988, and that disqualified her. I mean, my God, that's insane, right? I mean, that's nuts, but that's the world we live in.
I have a question. So you talked about the possibility of adding DC and Puerto Rico as states. Obviously, DC is in the bag for the Democrats, no question, but you seem to also conclude the same thing, like absolutely in regard to Puerto Rico, although, I've read some articles that are more questioning of that. I mean, Puerto Rico is, after all, it's run by their equivalent of the Republican Party, the more conservative party. They're certainly very socially conservative. I think in polls, like over 75% of Puerto Ricans are anti-abortion. So I mean, I've just seen things like questioning that it's an automatic Democratic asset. So I don't know if you have.
Look, I don't have any strong opinions. It's possible that Puerto Rico might prefer conservatives locally, but Democrats nationally. There's always that sort of split where, Montana might prefer a Republican governor, but a Democratic senator for some unique reasons. So I think on balance, Puerto Rico would probably send 2 Democrats to the Senate. Plus, you would have electoral votes and you would have members of the House. So, I mean, it wouldn't just affect the Senate composition. It affects also the presidential election because it becomes harder to get to 270. But I think those moves are inevitable. I mean, as soon as the filibuster is gone and Democrat control all 3 branches, I think you get statehood for D.C. Puerto Rico may not want statehood. They have this unique arrangement where they actually pay less taxes by not being a state. So maybe they don't want to roll the dice. But maybe there's incentives that, if Puerto Rico is admitted as a state, they get favorable legislation. There's ways of finagling that. Thank you for the question.
I can see to anyone else if they have a question. But
I hear a voice.
sorry, is someone else
I
talking?
actually did have a question.
Go ahead.
Yeah. So I was kind of wondering, also like kind of wondering with what Professor Oren just said, with like having a term cap for each justices and sort of like following the president and not always like being this weird game of like, you appoint someone and like forever until that person, well, decides to let it go or pass away. Like you just play that game, I guess, sort of. Is there another possible way that sort of the justices don't follow these political games, but more adhere to the doctrine if we still keep with this current system? Like, is there any other possible ways to do sort of the check and balances so that they're not too aware of the political scheme of things?
Well, look, so I'm amenable to term limits, but let me just flag a possible concern with them. Politicians have a very short time horizon, right? Trump really wants this pick because it'll help in the 2020 election. Do you think Trump would really care whether his nominee steps down in, was it 2038 or 2050? I don't know how a president today would willingly limit his own nominee's potential. So it'd have to be forward-looking, like it would take effect in 8 years or something, right? And what politician would pass something that only takes effect in 8 years on the outside chance that their party's in power at that point, right? In other words, politicians won't take a step that might minimize their party's power in the future. Party's power in the future, right? They're not going to do that willingly. So I think this sort of perspective change is unlikely. Also, I think you need amendments to do it retroactively. So you'd have some justices who are term limited, and then you have like Neil Gorsuch serving for 50 years, right? Or whatever he's going to serve. So I think you'd have this weird balance of people cycling in and out. One option that I think is actually the easiest to enact and perhaps the most effective is jurisdiction stripping. I don't say that phrase lightly, but there's no requirement to give the Supreme Court appellate jurisdiction over certain cases. And I think in some regards that's easier than packing. When we talk about court packing, that's merely the periphery. The problem is the justices perhaps doing too much. This is where Oren will get happy, right? If the justices do less, then there's less concern about what they do, right? If the court has a more narrow jurisdiction or more narrow realm of cases, people won't care as much. You know, can you even name all 9 of your states or 7 California Supreme Court justices? I can name maybe 1 or 2, maybe 3, right? Because they don't really affect me. I don't really care about them. But if they affect me, I sure as hell know their names. So if the justices become unimportant, then 9 is irrelevant. It's not very important. But the court has sort of aggrandized its power over the last 2 centuries in such a way that's hard, I think, to scale back.
I have a quick question. We're almost out of time, but if Trump wins re-election, do you think there'll be pressure for Justice Thomas to step down?
Yes.
Okay.
And Alito.
And Alito.
I think so, both. Yeah, I think there's a second term of Trump. I think both Thomas and Alito will step down. At that point, you would have basically, my math is right, 6 conservatives in their 50s, which Oren talks about like a permanent majority. That lasts a very long time. You know, Justice Ginsburg lived to 87. Justice Stevens was 90. I mean, if Gorsuch and Kavanaugh live as long as Stevens did, we'll be in the 2050s by the time these guys are off the court, which I think is unlikely because they'll be packed. How would you even have more justices? You have to expand the bench, maybe like Hollywood squares. They start going on top of each other. Ginsburg for the row, right? They've never seen Hollywood squares, obviously. It was a TV show where you would have like a tic-tac-toe board where they would stack on top of it. Yeah, now they're nodding. I don't know what that'll look like, but I don't think that we'll have a 9-member court for very long. I think eventually it'll expand. Something's going to happen. Roberts can't keep the ships straight forever. Eventually he's going to lose that power. And at that point, I think we go to 9, go to 11, go to 13, 15. If you ever see the Star Wars Episode 1, like the Galactic Senate, right? That's basically our Supreme Court. These little pods of justice floating around. We'll have the Yoda faction of the court. Or we could just start drawing random 3-judge panels from this Supreme Court of 1,000 people. We just have the entire American Constitution Society directory as just a Supreme Court Justice pro tem, and they just pick one at random. I don't know, right? There are different ways of doing this. But it's going to happen eventually. 9 was a good number, had a good run while it lasted. I don't know. No, I'm not optimistic. I'm sorry.
I have a question, a little bit, less related to the current, election and politics, but why do you think it is that the Republicans have been so keen to nominate Catholics, especially? I mean, the Catholics have been a very dominant force on the Supreme Court for a long time. At one point, they were all either Catholic or Jewish. Now, Gorsuch is sort of like Episcopalian, but he was raised Catholic, and it's sort of controversial what his real affiliation is. Obviously, I think part of the reason is that they're considered to be good on the abortion issue. But I mean, Catholics are not the majority of the Republican base, like evangelical Protestants are. Why don't they nominate evangelical Protestants more? I'm just curious about that.
Look, I'm Jewish. My good friend Oren is a fellow member of the tribe, so what do I know? I don't know. Maybe, I mean, look, Justice Kennedy was Catholic. That had that work out for abortion, right? I don't know what Justice Souter's faith was. Actually, I have no idea. I just don't know. But look, yeah, I mean, Kavanaugh was profoundly Catholic. Alito is devout. Justice Thomas is. Judge Barrett, I think, would be as well. Judge Legault is Catholic. I mean, you're picking among Catholics. There's no mainline Protestants. Maybe they're considered too squishy. I don't think it's pejorative, but maybe they're just considered not devout enough. You have to be hardcore. As far as the Jews in the court, they tend to be all the Democratic nominees. I would love a conservative Jewish professor. Could happen. Justice Orrin Kerr. I think Orrin would be a good judge. He would drive me nuts, but I would be okay with that. I would say, oh, come on, Orrin. All right, fine. You look good with a bow tie and a robe. I think it would work.
Yeah, the Justice Stevens look. And Valerie, I think it is largely a Roe proxy, because you can't ask the nominee explicitly about their views, because whatever conversations you have with like the White House counsel's office end up being disclosed during the confirmation hearing, and so they don't want to actually ask the nominee, but they can look, use that as well. If the person is a observant individual of the Catholic faith, they're probably pro-life, and so that's I think has been used as a proxy for a while.
Yeah, that makes sense. It's just one would also think the same with regard to like an observant Southern Baptist or Pentecostal, etc. It's just interesting to me. It's something I've wondered about.
Yeah, it's true.
I mean, I think Judge Ho would be great. I mean, he's also Asian too, so.
Oh, Judge Jim Ho. Jim Ho's on the list. I think he'd be fantastic. I would love. I think in this though, you need a female justice. So I think this is not Jim shot. Jim may have a shot. Judge Ho may have a shot. It's a weird thing when people become judges, you still call them by their first name, but you really shouldn't. Have to fight it and don't do it. Yeah, Judge Ho, I think would be wonderful. All right, anything else, Oren? Go. All right, thank you so much, Berkeley. I am so happy to virtually see you, and hopefully next year we'll all be in person. I'll have like a plexiglass shield around me. We'll have a little bubble, and we can have a fight of how many Supreme Court chairs we can stack on top of each other, like maybe a pyramid. That could work also. But the Chief Justice at the top, and they're sitting by seniority, and the groundlings at the base, don't really have a vote. That might work.
Thank you so much for coming, Professor Blackman.
Thank you so much
for your input, and thank you everyone else for just attending. And we'll see you guys back here at some next week with Professor Yu and Professor Kosh.
Ooh.
Thank you again, Professor Blackman.
Thank you.